We're incredibly fortunate to have attorney Mary Vandenack as our first speaker. She sets the tone for the day with her view on this year's critical practice changes. Mary Vandenack is an accredited estate planner, fellow of ACTEC, and member of many other impressive societies. She has 30 years of experience supporting private wealth clients in the areas of tax, private wealth planning, asset protection, business exit planning, complex trusts and estates, philanthropy, and state income tax issues. She is recognized for her innovative integrations of technology in the legal practice. She has been honored by the American Bar Association with the James T. Keene Award. She is a commentator for Lineberg Services, and Steve Lineberg, who has passed now, is a good friend of hers and nominated her for membership in the NAACP. She's actively involved in the American College of Trust and Estates Council, the ABA Real Property Trust and Estates section, as well as the ABA Law Practice Management Division. She is a, how does she do all of that? I can't answer that question, but it's my pleasure to give you Mary Vandenack.
Thanks, Patty. I'm really grateful to be here today and excited to share a little bit about 2025, what's been going on, and what we can be thinking about with respect to 26. So uncertain world is kind of the topic, and it is definitely an uncertain world out there. Interestingly, I always check the news when I'm talking about, well, what's going on in 2025. And so you may have been following that we had the tariff case before the Supreme Court yesterday, and some really interesting questions were asked about whether that tariffs are actually a tax. We're supposed to get a ruling on that tomorrow, so that I have to admit, I'll be watching my computer screen waiting for that to pop up. There's been a lot going on in 2025, as I'm sure you're aware. We've had quite a bit of regulatory change across the tax, trust, and reporting regimes. And keep in mind, when we talk about that, we really have to think about it both at the federal and state level. And one of the things I was just chatting with Patty about briefly prior to the session starting is that sometimes it's really easy to say, hey, I practice in Nebraska, Illinois, Minnesota, California, or New York, or whatever state, and kind of focus on that state for purposes of what you're doing without really paying attention to other states. And I think it's really important to also focus on what is going on with other states. So we also want, most everybody probably is familiar with the fact that OBA passed this year, and that was signed on July 4th and made some significant changes to the estate tax, income tax, and charitable planning world. Now, we're hearing that we're going to see an increase in IRS enforcement with enhanced technology. And most of you have worked with the IRS at all, know that it would be great if we get some enhanced services from the IRS. Obviously, the IRS has been downsized significantly this year, and if anybody's been on hold with the IRS, you'll know that the service isn't there yet, even with the enhanced technology, but my hope is that technology will help. We do have technology moving to the forefront, and we're fortunate to have Todd talking later on AI, but I will mention a few times I am an AI advocate. Patty and I were discussing a few of the challenges with it, and I'm sure Todd's going to address those. Super important. If you're using AI, that presentation will be incredibly important. We have, that just is coming along quickly, and one, you can end up being one of the cases, you know, that we're reading about, that you had submitted a hallucinated brief or something like that, or maybe we can be reading about that you are one of those who's developing a practice that is using AI enhanced legal services. And that's one of the things that I'm personally working on. So we had our typical inflation adjustments, we had OBA. So final RMD regulations were actually issued in 2024, applied in 25. And one of the things I'm going to mention is some of this, like I have 60 slides, I probably won't get through all of them, but I include all that information because I do think it's important. One of the things that I do when I'm preparing for a presentation like this is I attend everybody else's. And so I'm including some of these facts, but I'm not going to spend a lot of time on it because I really want to focus a little bit on, hey, what can we do in our practices in 2026? I think that matters more than rehashing. I think most of you probably can read, and so you can go through these developments. So I'm just kind of highlighting some of the things that's developed. I've already mentioned the IRS and the clawback in funding, and how that evolves in the IRS is going to be somewhat interesting. I'm going to actually lead a little bit with what can we do in 2026 so that I've at least touched on each of these things, and then I'll evolve a little bit as we go through some of them. And again, I might not get to all of the strategies, but they're covered, and feel free to forward any questions to me. I'm always open to questions when I've given a presentation. So the AI enhanced legal services, again, we have a whole presentation on that. I just think it's super important to be thinking about that. One of the things for 2026, it's really easy to get excited about all of our fun tax strategies, whether it's income tax or anything, but foundational estate plans remain really important. And I have taught trust and estates as well, and used AI to see if I could create trusts and documents in AI. And I'm confident that we haven't quite been replaced by AI yet. I do think that keeping a focus on your critical thinking and using it as a tool is going to help you. But I think people still need foundational estate planning. And I'll go ask ChatGPT or other services questions just to see where it's at. We still have jobs for the time being. And for the long haul, actually, I have my 21-year-old nephew is from what I call an AI family. His whole family is involved in an AI company. And so my 21-year-old said to me, Aunt Mary, what you need to be talking about is learning how to replace yourself with AI, because in doing so, you will be the master of AI. So that's what I've been setting out to do, is replacing myself. Haven't achieved it yet, but I have made my practice more efficient. If you are representing clients that are still subject to estate tax, lifetime transfers are still appropriate. And we're seeing an interesting round of elections on Tuesday. Although we have some thoughts, the supposed estate tax increase to $15 million per person exemption is supposedly permanent. I've seen permanent used in reference to a lot of tax changes recently, and I'd really say the tax changes have become somewhat bipolar, and I don't rely on the word permanent at all. One of the things is lots of clients have IRAs or 401k accounts. An important role that an estate planner can play is to really understand those tools. I see a lot of beneficiary designations that are interesting, to say the least, and not well understood. And I do see a lot of see-through trusts. Those are important tools to consider. Once upon a time, I was a big fan of see-through trusts, except that if you're doing it just to create an option to lengthen distributions, what I've seen on the estate administration side is most people cash those out and treat them like a bonus. So I told clients, stop paying me to create these trusts. But where I do use them is we occasionally have a beneficiary who just doesn't manage money or has some kind of challenge that we want to force the spread. And that's where I use those. Crypto-specific intake, that's become a big area. And we're really fortunate to have Chris and Chase talking about that later today. So I will leave that to them, and I'm hoping to learn about what they have to say. Best practices in all areas. I'm a big fan on dotting every I and crossing every T. Monitor the hot spots. State law trends. So again, I'm really a big advocate for know what's going on in your own state, but at least do pay attention to what's going on in other states, because one of the opportunities that I think we really have with OBA and the state law trends is to do some diversification of our clients. So jurisdictional arbitrage is the term that I use for that. CRTs, large IRAs if we have philanthropic clients, and I'll talk about that a little more. I'm going to do a super brief summary of OBA, and there are a lot more provisions that I haven't included, so I've really only included the ones that affect some of the strategies that I'm going to talk about today. So again, I've already mentioned the estate tax exemption at $15 million in 2026. Income tax brackets are extended, standard deduction increased, personal exemption is terminated. So I used to send clients, congratulations on your new personal exemption when they had a kid. Can't do that anymore. The AMT exemption amounts and phase out thresholds are extended, and we have the child tax credit. So the ones I kind of like that I'm really going to talk a little bit about today with some strategy is the qualified business income. So that's the Section 199A deduction. So we have a corporate tax rate at 21%. The QBI is essentially something that tries to give those who have flow-through entities a similar break. State and local tax deduction, we have this really interesting provision where you have a $10,000 cap at one level. So I like one speaker I listened to goes, well, write this down. 500,000 equals 10,000, 600,000 equals 40,000. It is a significant phase out range to the extent you have clients in that income range. The charitable deduction, really interesting. And this is where I've played to say, can AI figure out the cost of this charitable deduction limitation for these clients? So the first 0.5% of AGI is not deductible for itemizers. And then we have a cap so that if you have a client in 37% bracket, they only get 35%. Try and do that math. Fortunately, my dad made us do math in our heads because he said calculators weakened our mind. So I can do the math, but I will tell you that so far, when I do that math, it's not, when people are looking at, should we make a deduction in 2025 and give it all away before December 31 of this year, the math is not that significant when you take into account the time deferral of money. Trust charitable deduction, there is disagreement among the commentators. I'll tell you, I haven't concluded personally yet. Have you concluded on whether trusts are going to get the charitable deduction, Patty?
No clue.
Okay, because that's something I've been listening to, and I don't think there's a clear answer on that yet. And so kind of waiting to see. One of the things that would be nice would be if we got some clarifying regulations with respect to OBA, or whether we'll have any bills fixing and kind of telling us where we're going to go. So, and charitable corporations have a limit. Okay, Section 1202, I always like to mention this. I think 1202, if you do any business planning for clients, so I do both a little bit. Mostly I do exit planning these days, but it's not uncommon that I simply love entrepreneurs. So I do help a lot of entrepreneurs get started. Sorry, I stumbled over that word. But Section 1202 is a provision that allows qualified small business stock to exclude up to $10 million in gain. And so OBA gives us some enhanced ability to use this for small business owners. So I just like to say, if you're estate planning, you have a client who has a business, make sure you take a look at whether they have any ability to have 1202. If somebody's just opening the dress shop down the street, it's maybe, maybe not. But of course, they might go onto the internet and become an international clothier, right? So I'm always thinking about, is there any 1202 opportunity for my client? So we have some enhanced ability to use qualified opportunity zones. I can barely talk about that without spending at least 120 minutes, so we'll just mention it. 529 accounts with a little bit of an enhancement there. By the way, the national debt limits have been increased. And the interesting fact, and it was from Steve Oceans, and I called him up and said, Steve, I just want to know, I want to fact check this information. Is a concerning thing is that we are actually now paying more interest on our national debt than we are paying for defense. And that's always a concern for just a society. Other notes, there's just amounts that we've added in this bill, not so much for estate planners, so I won't spend any time there. So let's talk about the federal estate tax landscape. And again, I know that it's a very small percentage of people that are subject to the estate tax. I am blessed to work with several, and I think it's important to at least be aware. But what I do think is important, it's really easy to say, hey, the exemption's 15 million, 30 million if you're married. You just don't have to worry about that. We saw some blue-oriented elections on Tuesday. So my comment is, we don't know what's going to happen in the fall. I'm just not a fan of the word permanent. I think they should eliminate it from the tax code after the last many years. My head just spins every time there's a tax change. We pass them through budget reconciliation. So I just say, don't totally rely. I don't feel a sense of urgency this year to use the exemptions. It also does not, however, eliminate the possibility of using non-grantor trust strategies for the modestly wealthy, your 1 to 10 million client. There's still a lot of things to think about. And you do want to look at, is this a client who could potentially grow? I've had some clients who started what looked like it was going to be a small business. I had a guy walk into my office with this little piece of metal that turned into this patent for a bike. And then he ended up being an extremely valuable asset for him. So I'm very much don't completely disregard that the estate, somebody could go ahead and exceed the estate exemption. Obviously, it's not the priority at a certain point, but I'm always at least thinking about it and footnoting it. I would continue to file 706s for purposes of portability, especially to preserve that ported exemption if we have an estate tax drop. So, a year ago, we were worried at the end of the year we were going to have this reduction. That didn't happen. But I'm still filing 706s for portability, even in a smaller estate. Some states still have significant estate or inheritance taxes. I was talking to Todd, one of our speakers last night, about Maryland. And Maryland has a $5 million exemption, has a particular strategy that you can use. So you want to be thinking about, am I in a state that has their own estate or inheritance taxes? And depending on how budget works out, you may see more states deciding to pass state and inheritance taxes. So that's one of the trends to keep an eye on. Income tax planning does remain particularly important in the current environment, and grantor trusts and non-grantor trusts are worthy of consideration. So basic estate planning, I just like to talk about that again. It's really easy to get into all these fun strategies. I attended a presentation recently that reminded me how much we do have to do. They had 97 different types of trusts that they talked about. And it was, as they were going through that list, I was like, oh, wow. I mean, I dropped a lot of trusts. It just didn't occur to me that there were 97 different types of trusts. So there's pet trusts and gun trusts and special needs trusts, and there's trust after trust. So there's a lot of needs out there. And one of the things is, I asked AI after that presentation, can you identify all the possible types of estate planning trusts? It did not match the list of the presenters that was provided. So it hasn't quite caught up. Now, they probably put their PowerPoint out there and AI is learning from it. So maybe the next time I ask it. But those tools are important. And part of our basic estate planning process is really saying, what are the tools that the client needs? One of the things with estate planning that I'm big on is implementation of estate plans. Often we give the client some documents and we might give them a letter suggesting they coordinate their beneficiary designations. And in one recent case that I'm working on personally, I had a client who wanted to be skipped, and so did an amendment, and this was where I was working with a different group. What happened is the trust said, hey, all of the assets are going to skip me, my client, and go to my kids. And that includes any assets that are passing by beneficiary designation. We sent a letter advising the change of the beneficiary designation, got missed. And so contractual designations prevail over what the trust language said. So really kind of following up, what I've gone to doing is with clients saying, let's just touch base in 6 months and make sure all those I's are dotted and T's are crossed so that we can make sure that the planning that we've done doesn't fail because we didn't implement. Asset protection, some people treat asset protection like it's a separate practice area. I will suggest that one of the things that you can really do is incorporate asset protection into your basic estate planning. It's super important. So every trust I draft, I think about asset protection. When we're talking about LLCs or how we're structuring the assets, I'm looking at, can we use an LLC? It's another thing that's important to a lot of people is privacy. And so that's a piece of the basic estate planning. Should we name this the John Doe Revocable Trust? First, we confused everybody with revocable versus irrevocable. Let's explain to them, hey, this trust named revocable is now irrevocable because the grantor died, and it's John Doe. But maybe it should be the, I don't know, the Packers Trust, since I'm in Wisconsin today, or something like that. Incapacity planning and asset management, I will tell you, I am a big advocate of trust over transfer on death and beneficiary designation planning, because what I tell clients, that's great that you've used all these TODs and beneficiary designations. But to me, like when I'm dead, I'm dead. But when I'm incapacitated and can't handle my own affairs, that really matters to me, that I have things structured in a way that, one, I'll be taken care of, and that I have somebody who can step in that I trust. And yes, you can use powers of attorneys, but I am really an advocate, and I have quite a bit of elder clients in my practice, so that's maybe a little fairly passionate about this statement. Is I think incapacity planning is just so important. I had some clients in my office this week. Well, what about if we're both alive, but we've both lost it? What happens then? How do we manage this? Who do we trust? Very important questions to discuss with clients. Traditional transfer planning issues, again, remain. One of the things is sometimes it's so fun, especially when we're worried about the estate tax exemption going down. We give away all of these assets to the trust. And to me, is the first goal in my work with a client is let's make sure you are taken care of for as long as you're alive. And if you have a spouse or dependent children, I have clients that have kids in wheelchairs, there's with long lifetime diseases. We want to make sure that those basic objectives are taken care of and the client is taken care of during life. So really doing what are the client's objectives and making sure that our plan isn't just, some people think this is just a template. I'm like, this is not just a template. Here, let me give you this document and see if you can make it into a trust that's really specific to you. I think that's part of our value, is that we do this a lot. We figure out who the client is, and we talk to them about what is really going to make sense for your disabled beneficiary, or the child you have that's been divorced 3 times, or the minor who's really struggling to manage finances. I'm a big advocate of avoiding probate. I know everybody doesn't feel as strongly about that as I do, but I'm very much an advocate of trust administration, keeping it privately. Recently, I was working with a testamentary trust, and all we wanted to do was to change the trustee. It was an estate where we actually had to go to court just to change the trustee. And in some cases, there might be reasons for that. In this, there really wasn't. Privacy, I've mentioned. The effective disposition of assets, that's the implementation I've talked about. Protecting beneficiaries from themselves. So a lot of my clients very concerned about, hey, my kids are doing okay, but I have brand new grandkids. I'd like to provide for them, but I have no idea how they're going to turn out. The other thing is I always raise it, and I think that we have an obligation when we're talking with husband and wife to talk about what happens when one dies. I know it's hard, but I just say, well, what happens if she dies and he remarries? And I always couch it, he's grieving deeply about the terrible loss that he's suffered. And so he's at the most susceptible moment in his life. And so this, 30-year younger person comes along, and it happens too. I mean, I have had it happen in my practice. So I think that's really important that we talk to our clients about those concerns in our planning and say, okay, let's talk about what happens when one of you passes away, and making sure that we cover those type of protections. So some of that lifetime planning is as important or even more important than some of what happens post-death and gives us a significant role.
I find that that's a real resistance point when you're talking to spouses about what a surviving spouse might do. And it's very important because I have many tragic estate administration cases where the children of the first marriage are cut out by the surviving spouse. It's very important and it can't be emphasized enough, I think.
I think it's super important. And one of the things I talk to clients about is that a lot of times kids and second spouse get along great while you're alive. And then all bets are off once you're gone. So I often suggest that the client make sure that the kids get something that they don't have, especially if they married somebody 20 years younger and the kids are close to the same age, is make sure that they're getting something immediately upon your death, even if it's a smaller amount, right? So, and I'm also a big advocate of the premarital planning. And one example, it's in your materials, you've been given this playbook that's in the resources that you have, is a recent case out of New York. And it was just came down within the last several weeks. And I think it's super important, and its initials used, so I think they were using the privacy. But the case was this husband and wife got married. Husband was doing really well in the financial world. Spouse also worked. They had kids. They did what a lot of clients do, is they put all the assets in these trusts, avoiding estate tax. Well, those trusts grew into significant amounts. And this is where we have an intersection of, and this is a really important thing that's going on that hasn't hit every state yet. We're seeing it in Massachusetts, Connecticut, and now New York. And so you have to be a little concerned. I've also seen a little bit of it in California, but it's worth thinking about is when we set up these trusts, is the property that went into these trusts a marital interest? And the particular case that's in your materials is the court took and ruled that the entire marital estate included the amounts that were put in irrevocable trusts. Mind you, husband was not a beneficiary of those trusts. He had no power of those trusts. And it ended up that they awarded the spouse, the wife, all of the marital assets that were outside of the trust. And so here is spouse, husband, who has basically owes money that he has no access to because they included the entire wealth in those trusts as part of the marital estate. Important trend, the case is going to be appealed, and we'll see what happens and how that comes out. But we are seeing some trends to include our trust. So part of that, and I talk a lot about that asset protection feature in estate planning. And that's one of the things that if we're doing a basic foundational estate plan for a client, we want to be thinking about the provisions in our trust and whether they are going to withstand situations like that. Another thing that I like to mention is that, hey, we might live and practice in state X, but our clients might move. And that's another reason I think it's important to pay attention to the state law trends and draft trusts that are flexible, that can move with the client, so that we're always thinking is where is this going to go? What happens in terms of if they move? So basic estate planning matters. The asset protection is a part of that. And I'm just going to talk a little bit about the asset protection. I've covered a lot of it, but I really suggest when you're talking with a client, thinking about what I call jurisdictional diversification. A lot of times we create a trust that says, this trust is governed by the law of the state of Illinois or Wisconsin or the state that we're in. You can make that language more flexible by saying something like, this is governed by, and there's a difference between situs and governing law, by the way. And situs is one of those terms that's like trust. So situs has multiple meanings you want to be aware of. But what you do want to be aware of is thinking, what if somebody moves? What if a beneficiary moves? What if the settler moves? Can I make this trust a little bit more flexible in the way that I use that language? I'm not going to spend a lot of time on the asset protection basics, but we do look at those in structuring the estate. I want to be careful when I'm doing the asset implementation and coordinating the assets that I don't ignore the possibility of protecting assets from creditors as part of the process. I do love wrapping LLCs around assets, and I'll use different, like one of my favorite things is Wyoming has one of the best single member LLC laws in the state. And so I'll wrap a Wyoming LLC. Oh, and they have no state income tax as well. So I don't have source income rules if I use a Wyoming LLC. But I like to do that for privacy and asset protection. So I practice what I preach. My own investment assets are in investment LLCs. So an asset protection trust are worth looking at. So if you can't get a premarital agreement, you can do an asset protection trust. And if you do that prior to the marriage, you will have some protection from that. Secure Act, I'm not going to spend a whole lot of time on this, but we had final regulations that went into effect in 2025. I do think an area that you can really stand out in is being familiar with the retirement plan rules. They're complicated is probably the kindest word that I can come up with about them.
Draconian.
And draconian is another word. And each time we have new regs, they don't get any better, right? So the thing is, we do still have, you can make direct charitable contributions once you hit 70 and a half. So that's an important point, that we have the RMD age is increasing to 75, but you can still make direct charitable transfers. And there's an advantage to that over taking a distribution and making a charitable contribution. On the other hand, if you have a client who's under 70 and charitably inclined and has sufficient assets outside of that, it's still not for all clients. It's a do the math type of situation. Don't let AI do that for you yet, but because it's large language model. But there are still times that it makes a lot of sense to go ahead and make a charitable contribution from an IRA distribution. The see-through trusts, I've really already talked about that. I primarily use them if we're trying to create a situation. I have one client whose kids are in their 50s. They have not really developed any type of income or careers, and he continues to fund them. And so we're trying to make a trust that will make sure that they have assets to cover them for a lifetime. So a good thing to look at it, if there are any see-through trusts, retirement plans with the new Secure Act rules, a good place to familiarize yourself is get familiar with those rules and review those trusts, but review any IRA or 401k designation. It's amazing to me how many times somebody is just letting the contractual provisions control where their significant 401k account or their IRA is going to go. And I'm big on, don't do just a primary beneficiary. Look at contingent and successor beneficiaries, which are two different terms and apply differently. So the non-grantor trust is one of the strategies that will be significant and come into play in 2026. The non-grantor trust is not a tool that exists only for the super wealthy client. A non-grantor trust is something you can think about for the modestly wealthy trust. So we talk a lot about the grantor trust, which is used mostly for clients with estate tax exposure. And even those with estate tax exposure often hate it when they realize they've given the assets away, but they're still paying the tax on the assets. So while it's a love strategy among estate tax planners because it's going to reduce the estate, clients often hate it. So we use a lot of exit strategies. The non-grantor trust is a little different in that the non-grantor trust is like its own separate person for tax purposes. So it is its own being. A lot of people will criticize the non-grantor trust because what's true about it is it does reach the highest tax bracket at a very low rate. So $15,650, you're paying tax at the highest rate. On the other hand, the trust, the non-grantor trust, capital gains are taxed at the trust level. And we have this concept in non-grantor trust, very important one, called distributable net income. And so the concept of distributable net income is, well, who's going to pay the tax? So I look at a non-grantor trust as an opportunity to create additional tax brackets. So for the non-grantor trust, I can name, in one case I have a client, we have adult beneficiaries and they have adult grandchildren. So we could create a non-grantor trust for each of their kids and grandkids, create multiple beneficiaries. We take that distributable net income and we look at, well, what's the income in the non-grantor trust? What is the income of each of these people? Who can bear some income tax? And basically we can make distributions of income. And if we make a distribution of income to a beneficiary, it's a deduction for the trust. Just to look at it simply, I won't get too complicated about D&I, but it's a tax deduction for the trust. And the person who receives the income pays the tax on it. And the really cool thing about the non-grantor trust is, as long as it's designed as a complex trust, is you actually have till March 5th of the year after. So we get to the end of 2025 and we can actually gather all the income and figure out what everybody's income actually is. Because, sometimes we have cash income dump in at the end of December that we didn't account for in our November tax planning meeting. But we can distribute that income 65 days after the tax year, and whoever receives it is going to pay the tax on it. So the non-grantor trust in general creates tax planning opportunities from that income tax perspective. So I wouldn't overlook it just because it's subject to tax at $15,650. It's also a superb asset protection strategy. So I use it for both.
I agree that that's a very good strategy. One of the difficulties is that D&I usually does not include capital gain. So capital gain gets captured at the trust level and can't be distributed. So it reaches, the highest rate at the $15,000 mark. And also the net investment tax applies, the NIT. So it would be wise to consider drafting provisions in the trust that would allow the trustee to make some allocation of capital gain to D&I, so you can carry that out as well.
And you're exactly right on that. That's typically what I do. And again, I'm a do the math girl. So what we do at year end is we actually look at how that income can be distributed, both the income and the capital gain, and how it will impact the recipients, right? Because a distribution of capital gain to one of the beneficiaries may have a different impact than distribution of the capital gain to another beneficiary. So it's very much a do the math. And also consideration, to Patty's point, is what assets go in the trust and how the investments in the trust are structured. So those all make difference in using the non-grantor trust generally. Some of the things with OBA that are developing as options in terms of using the non-grantor trust is the state and local tax deduction. So one of the ways that we can use these trusts is to look at this. Now, the example I'm giving works out very magically, and it's not going to work that magically, but I used a magical example just to illustrate, right? So again, that number is, we have a limitation of $10,000 for the $500,000 client. We have a limitation of $40,000. So what does that mean? So you have state and local income taxes. And the state and local income tax includes property taxes, all the taxes that you pay at the local level, state income taxes. If you're in a state without state income taxes, then you might have less an issue with that, but there's sometimes pretty high property taxes that fall into that category. So far we've looked at this for a lot of different clients. So one of the things we do with the non-grantor trust, and there are other strategies such as using an LLC as well, but we can use one of the non-grantor trusts to shift some income. So the example I've given, and I always hate it when I find a typo in my PowerPoint after it's posted, but I'll get there. So we're just going to go with Sam and Sally, and they have together a modified adjusted gross income exactly at $600,000. And they have a non-qualified income producing account that generates exactly $100,000 of income annually. So we have Sally create a non-grantor trust, and we put that non-qualified annuity into the trust, we shift that $100,000 of income into the non-grantor trust. We now shift that, by shifting that income, we give them the full $40,000 state and local tax deduction. Assuming they're in a high income tax bracket, you do the math on that. So 37% plus, let's assume state of tax, I'll just do 40 because I can do the math in my head. That just saves $16,000. So that's one of the things that we're looking at. And would I do a non-grantor trust only for that? That's a big maybe. I'm probably going to be using a non-grantor trust if I have a variety of factors that lend themselves to go ahead and use that. But once we have it in that trust, as we talked about, that income can be accumulated, it can be distributed, can be used to make charitable contributions. One of the things that I have gone to with my trust is naming as a potential, giving the right to distribute to charities and also LLCs, by the way. So let's say we suggest to a beneficiary, you should wrap an LLC around yourself for asset protection. We need to make sure that the trust has the right to distribute to that LLC versus the beneficiary, or we've defeated the asset protection that we tried to do. But it is like a year-end tax planning. Pretty much most of the time what I do in November and December, other than occasionally giving presentations, is the tax planning where we're looking at, because once December 31 hits, then you can't make any changes. And as an estate planning attorney, one of the things that you can really provide value to your client is coordinating with their accountant and life insurance advisors and saying, it would be really helpful to have a year-end planning meeting. Let's look at the estate plan. Let's see if there's any income tax things that we can consider for you this year. And a lot of times they show up and there is something that happened that year that's really important. Another advantage of the non-grantor trust is 1202 stacking. 1202, you can probably tell, is I'm really biased. I love the 1202. I've personally had the opportunity to use this with multiple clients. And so how that works, so what 1202 means is, let's say husband and wife start a business and they each own some of the shares in it. It's qualified small business stock. It has to meet some specific rules, and I have provided those in the materials. I'm not going to go through them, but it's always a question to ask is the stock, which by the way, it can be an LLC that elects C corporation tax status. So it doesn't have to be a C corporation. And one of the things that you can do when planning with a client is if they have a business that is not, is you can look at that business and say, are there opportunities to spin off a piece of this into an entity that will be eligible for 1202? But let's just say you have a client started a business and it's taken off and that their ownership interest qualifies for 1202. And let's say all of a sudden they're looking at doing an IPO. And so they're saying, wow, this is going to be a huge amount of taxes. Well, you could say, well, sorry, you just made a small fortune. Or you could do some tax planning and say, let me tell you about this 1202 stacking thing that'll make your client really, really happy. And so you can use a non-grantor trust and put some of the shares in there, and that trust will also get its own separate exemption for income tax purposes. So up to $10 million of gain can be excluded. The word stacking comes from, I've seen some attorneys get super creative. We have a grantor trust and we split out a share of that into a non-grantor trust. We create multiple non-grantor trusts that they have to be different, so different beneficiaries. I saw one guy that named his uncle as the beneficiary of one and his brother as the beneficiary of one. And so I'm like, well, okay, do you really want them to be the beneficiaries? So maybe we don't really need 20 stocks, but it's definitely an opportunity that you can create a 1202, a non-grantor trust. And again, and while in this area, if I have a client that has 1202 stock, I might create a non-grantor trust for the sole purpose of using that 1202 exemption, because that's a pretty significant savings that you can create for a client. So using this strategy, it is important that, if we do more than one, you need to document why you're doing it, different trustees, beneficiaries. I use that jurisdictional arbitrage in this instance. So I might create one of these non-grantor trusts in Delaware, which, by the way, you can avoid income tax. So, or Nevada is another state. You can create a non-grantor trust. They have great asset protection rules, and you can avoid state income tax depending on the asset that's in that non-grantor trust. So if you have a client, and by the way, even a lot of investment assets, you can create a non-grantor trust in a jurisdiction with no income tax, get a client asset protection and some income tax savings. So it's worth thinking about. The QBI deduction is another area that we're using the non-grantor trust this year. So there, same thing as the QBI deduction is one that allows pass-through businesses to deduct up to 20% of what's called their qualified business income. And there's a technical calculation to that, of course. Your eligible tax players, I've laid out who those are, but it has to be somebody who's getting flow through income. And what we're doing, and you know, the limitation on this, and it always kills me because aren't there a lot of lawyers in Congress? They always apply these limitations to professionals. And so lawyers always get excluded from the tax breaks. I'm kind of like, why is that the case? As a lawyer, I'm like, you know, already if I have a professional corporation that used to be that I had to pay 35% tax on that no matter what. And then when I distributed, I had to pay income tax on it. Now we have this lovely little the QBI, and it says, well, unless you're a lawyer, you can't use this, or if you're a certain professional. So there's a limitation on that. So one of the ways that we can do that is to go ahead and use this trust. And again, I've used one of these examples that won't magically work out in real life, but it is a consideration. So let's say we have Dr. Jellison and he has a medical practice. Well, this is a specified service trade or business. So he gets phased out of the deduction at a very low level of income. He also owns the building in which he operates. And in that building, he has other tenants. And that's kind of important because if it's just his only building, we're going to have trouble qualifying this as a business. So we're going to say, hey, we want to make his rental business into an actual operation. And by the way, sometimes what I do is say, maybe have the spouse own that or a variety of other strategies. But their taxable income is currently right at the amount where the QBI deduction is going to be phased out entirely. So we're talking to that client and saying, oh, well, what could we do? So we're going to create 3 non-grantor trusts, and we're going to do one for each of his 3 children. Now, there's ways you can include the spouse as a beneficiary if you like as well, but that's a whole nother presentation. So I'm just going to mention that it is possible. So if you have the spouse going, hey, but we're trying to get the income off their joint return in this case. So we're just using for this example that we're going to do 1/3 for each of the trusts. We're going to put a 1/3 interest of the LLC in each of those trusts. And by doing that, we shift off of the Jellison's return the exact amount, which will get them below the phase out and allow them to take a 20% deduction for the income from the medical practice. And so again, the math isn't going to work out that readily. And this is a strategy that I use when I'm using other strategies that go with it. So that's one of the uses of the non-grantor trust. So basis adjustment planning also is an important tax planning. So a lot of people just love to do their gifts, and that's great. And beneficiaries love to receive those gifts. One of the things that just sort of off the top is if you have a client who's gifting, regardless of whether they need to for estate tax purposes, the trend I've seen is those who like making gifts to their kids. A lot of times they want to see the kids benefit while they're alive, and that's great. What I want them to do is to keep in their estate the assets that are going to get a step up in basis on death and give away the assets that are not. So by way of example, I got a call after the effect a couple, like 2 years ago, from a client who called up and goes, I think I need you to file a gift tax return. I gave away $3 million in value of my Apple stock or something like that. I was like, wait, what? Right? You had 3 million in cash. So what happened there is, right, if this particular client who is 94 years old, and I'm making this up sort of kind of, but it's sort of based on something a client did. But let's just say I have a 94-year-old client who gives away their Apple stock instead of the 3 million in cash. So what just happened there? They die the next day. The 3 million in Apple stock does not get a step up in basis. And if the kids sell that so they can enjoy that $3 million in value, they have to pay the taxes on that. Whereas if that were owned in the estate at the time of death, they would have got a step up in basis to the 3 million. They could have sold it for the next day with no gain. So really, to the extent you have a client gifting, strategically thinking about the basis of assets and what that gifting should look like. And I just like to mention that applies because I just have clients gifting away to grandkids, and they like to gift away that appreciated stock. And I like to talk about to them about, let's talk about that basis at death and how valuable that step up in basis is to your kids and grandkids versus transferring the stock. And so I've kind of covered that. Okay, so some of the other strategies for basin planning, and it's kind of one of these things where one of the trends that I really talk about right now is remaining very flexible in terms of estate planning. That's really important. Design flexible trusts and flexible plans. Because what I feel like, again, the word permanent is laughable to me in the current environment. It just isn't permanent. So when I'm structuring trusts, what we look at is saying, well, what do we want to include in this trust? We might want to include what's called a formula general power of appointment. And again, that's a whole hour conversation. So just at least know these are some of the strategies when we're talking about planning for basis. There's things that you can do. We want to be able to toggle on, toggle off. We do that with the grantor trust. Power to substitute. So if we have a trust that is a grantor trust versus the non-grantor trust I've been talking about, we can use that power to substitute. If we put assets in there that have grown, somebody's about to die, we can use that power. So I'm just noting the comment, parents in their 90s, they do not get this stuff. Can I just tell you that I and two of my siblings are trust and estate lawyers. I have a 95-year-old uncle who's a really smart guy. My mom passed away in June. At the funeral, my cousin came up to me and said, Dad hasn't done any estate planning. So his wife died about a month after my mom died. And so we did the estate planning. You just got to keep talking to them about it. And it's you get them to talk to the investment advisor, try and get them to talk to somebody because it is so important. So I'm going to go to my last thing I just want to mention because I love this, the charitable strategies, and it's one of my favorite things to do. And what I'm just going to take a minute to talk about, we've had these changes to the charitable deduction, and that I'm going to tell you the math I've done. You need to be aware of those changes, but I'm not telling clients you have to make these gifts by the end of 2025 because that's just not the case when you do the time value of money math. Now, if somebody's doing a 20 million gift to, a particular university to fund a particular research, those dollars add up a little bit more. But on your smaller $10,000, $20,000, $30,000 gift, I'm not feeling like it's a huge deal. Now, again, I'm a do the math girl. What I do want to talk about for a moment is what a trend I am seeing in charitable planning. So I attended a charitable presentation recently, and what I heard was DAF, private foundation, CRT, CLT, all of the standards. What I will tell you is that I'm seeing clients not always caring about whether they're going to get the charitable deduction. They want to have some flexibility. There might be control. I have a client who developed of his own accord, he's a physician and a researcher, developed some intellectual property, but got where this thing could be hugely helpful as kind of some gene research. And what he discovered was something that could help a particular disease that really doesn't have solutions yet. And he wanted to develop that, but he wanted to benefit from all of the work and financing. So we ultimately did a combination strategy where he continued to own the LLC and had certain rights, and we controlled the way it was disclosed we created an accompanying actually 501c3 that's a public charity. It wasn't a private foundation. I'm seeing a lot of trends like that with clients in terms of using combination strategies. So I just suggest thinking out of the box when you have a client who wants to do something that is philanthropic in nature. And there's just a lot of that going on in the trends that I'm seeing in this area. And the other thing I'm just going to mention, and Sarah and I are going to talk about this in our next presentations, seen a lot of clients who are worried, well, what if my kids turn into, little jerks, or the grandkids are awful? So one of the things we're doing is putting charitable advisors and directors in direct to trust to create a drain. A way to say is, if all the kids end up being schmucks, then let's have a structure that allows some of this to be drained off to a charity. And so those are just a lot of options. So I'm just going to take my very last minute and talk about what should we be thinking about in 2026. And so I mentioned, that's not on the slide, but I think is super important, is the jurisdictional arbitrage. Think about LLCs in different states. Think about trusts in different states. It's not always the state that the client lives in that makes sense. Think about being flexible. Think about whether the non-grantor trust works. The income tax right now is the bigger concern for most. Think about the directed trust. Charitable strategies are evolving. And AI is changing our industry. So consider developing the AI-enhanced legal experience. And you will get to hear more about that later today. I want to thank you very much for listening today.